A lot of people ask, when can I modify custody? There's no set number, but there must be proof of a substantial and material change since the entry of the final judgment. The purpose of that rule is to protect finality. In other words, the judges don't want to see you every single year based on whatever happened. The goal is finality. Now, that finality can be overcome by a substantial material change in circumstance. For example, perhaps your ex moved further away, and now getting the kids to and from their house has become increasingly difficult. Or they become a drug addict. Yes, that is a substantial change. Or they have a new boyfriend that's abusive. That can be a substantial change. There's no perfect answer, which is why it's so important to call an attorney and find out if your situation is applicable for a modification. A modification is requested by filing a supplemental petition for modification. It's a very particular document that has very specific requirements. In Hillsborough County, there are even more requirements pursuant to the local administrative order. If you fail to file your modification with the appropriate requirements and attachments, your case will be dismissed. Make sure you have an attorney who knows what they're doing when modifying a case. In a modification, the factors are the same as the original divorce or original parenting plan. However, with the added level or the added layer that there is a presumption in favor of the original final judgment. Keep in mind, the judge at one point in time said the original parenting plan is in the best interest of your children. That is a court-established fact, meaning that when you walk into a modification case, you are competing against the original final judgment being presumptively correct. Modification of custody hearings are very challenging. You must hit each and every element and present evidence to address each and every factor. In a case I just had, the other side failed to introduce appropriate evidence and testimony for the factors, and as a result, the factors went grossly against them and for my client, despite the reality being the other parent was way more involved than my client. But we knew how to prepare and we knew how to present the information. Again, court is not about the truth. It's about the truth that you can prove. You have no idea what you're doing, I promise you. Hire an attorney that does it every single day. Modifications are some of the most emotionally challenging cases. The reason why is because there's already a parenting plan in place. And one parent, the one who's not modifying, is typically happy with that parenting plan. They are going to stall and delay the case as much as possible because they do not want to change. Whereas you seeking the modification, you do want the change. You're going to want things to speed up. And the unfortunate reality of the court system is it's very slow. Make sure you have attorneys on your side that know the rules, know the judge, and know the requirements to modify so they can push your case forward as quickly as possible. Be patient, be trusting, follow legal advice. And if you're in the Tampa Bay area, call us or reach out on our website at tampadivorce.com, tampadivorce.com, tampadivorce.com.